Good morning. The July the 13th, 2016 meeting of the Board of Estimate is now called to order. In the interest of promoting the order, the order and efficiencies of these hearings, persons who are disruptive to the hearing will be asked to leave the hearing room immediately. Meeting of the Board of Estimates are open to the public for the duration of the meeting. The hearing room must be vacated at the conclusion of the meeting. Failure to comply may result in a charge of trespassing. Madam Deputy Controller, are there any corrections, additions, or deferrals on the agenda?
Good morning. For today's agenda, as the first announced, in the absence of the Honorable Mayor Rawlins Blake, Mr. Henry Raymond will sit and act on her behalf. The board received a supplemental protest for page 112 to 113, items 7 and 8 from Metra Industries. In addition, the board received a protest for all items on the agenda, pages 1 to 127 from Ms. Kim Trueheart. The board did review her protest, however, it will not be heard. I have the following abstentions and no votes to report. Acting on behalf of the Honorable Mayor Rawlins Blake, Mr. Raymond will abstain on page 49. The Honorable President Young will abstain on page 41, number 1, and page 125, number 3. In addition, the Honorable President Young will vote no on page 103 and 104. There are no abstentions for the Honorable Comptroller Pratt. Remaining on the non-routine agenda are pages 108 to 109, items 1 and 2, pages 112 to 113, items 7 and 8, page 113, item number 9, and pages 122 to 123. Mr. President, members of the board, those are the protests we received, as well as the items that will be abstained on or voted no. Thank you.
Thank you. I would direct the board members' attention to my memorandum from my office dated July the 11th, 2016, identifying matters to be considered as routine agenda items together with any corrections and additions that have been noted by the Deputy Controller. I will entertain a motion to approve all of the items contained on the routine agenda.
Move approval of all items on the routine agenda.
Second.
All those in favor say aye.
Aye.
All opposed, nay. The motion carries. The routine agenda has been adopted. The first item on the non-routine agenda can be found on page 108 to 109, items 1 and 2, and page 113, item 9. We're going to hear both of them together. Will the parties please come forward? Are they here? I'll entertain a motion.
The absence of the protestant, Ari Harrington, I move approval of the recommendations of the Department of Public Works on these two contracts.
Second.
All those in favor say aye.
Aye.
All opposed, nay. The motion carries. The second item on the non-routine agenda can be found on page 112, items 7 through 8. Department of Public Works, Office of Engineering Construction recommendation for contract award rejection. SDC 7771.
Good morning, Council President. Art Shapiro, representing Department of Public Works, Office of Engineering and Construction. We're presenting project SDC 7771, drainage repairs at various locations. Bids were received, and a recommendation from the Office of Engineering and Construction, Department of Public Works, is to award to the apparent responsive low bidder, R.E. Harrington, $4,442,755.
Good morning, President Young. My name is Joe Kovars, and I'm with the law firm of Oberkaler, and I represent Metra Industries. And with me today is Mr. Robert DePonte, who's the Vice President and resident in the Baltimore City office of the company. if I may proceed to explain the protest?
Okay.
Thank you. Metra is a longtime contractor with the city. They have performed many contracts successfully. They have offices in the city. They believe that their bid is the bid that complies with all the requirements of this invitation for bid, and the apparent low bidder, the bid of R.E. Harrington, does not. And there's two reasons why it does not. The first is that the bid is essentially a jumble, a mess of erasures, whiteouts, corrections, and none of these corrections are initialed, which are required by the bid instructions. So they've been identified at least 10 situations where there are problems with the bid. There are also places where the bid does not match the words and the numbers. And there are several places where that happens. And then the third problem is that the duplicate of the bid, which you would think would be an exact copy of the bid, is different than the original of the bid. Now, we know that the duplicate is not the official bid. However, when you take this whole range of problems, the fact that there are so many erasures, there are so many discrepancies, Mr. Mullen, counsel for the solicitor's office, did a memo, which we got a copy of late in the day on Monday, which identifies 10 situations where there are these discrepancies, 10. So, you know, in baseball, 3 strikes and you're out. How many mistakes does a bidder get before they are beyond the level of just minor irregularities? This one is so messed up that I think there's a major question of what is the intended bid and what is the intended bid amount? And it puts a cloud over the process. It brings the procurement integrity of the process into question. There's a 1-hour window of time after the bids are turned in between that and when they're opened. And who knows what happened here, but why would a copy be different? You know, a photocopy machine doesn't change what the original says. That, you know, photocopy machines don't do that. So why would a photocopy be different than the original? Something is off color, off smell. I don't know what adjective we'd use for it, but there's a cloud here. There's a problem.
Do you have any basis for your suggestion that there was some alteration occurred between the time that the bids were turned in and in the possession of the city until they were opened an hour later?
There's no good explanation as to what happened. We don't know what happened.
But you don't have anything to indicate that any alterations occurred during that 1-hour period when they were in the hands of the city, do you?
No. But the problem is that we don't know. There's a question over the process. And so, yes, the board has the power to exercise its discretion to waive minor irregularities, and we understand that. We get that. But there are so many here that we think that this is not the kind of case that should be waived. These are not minor irregularities. The second point is that if the city follows the rules, which are pointed out in Mr. Mullen's memorandum, where you have these discrepancies where the words are different than the numbers, then you have to follow the words. You have to use whatever the figure is, the dollar figure is in the words, and take that through the bid and then do a new total. And Mr. Mullen did his analysis, and he determined that it was about $49,000 and change more. And others have done an analysis, and we have done it, we're off by a few hundred, someone else is off by another few hundred. But we're talking about $49,000 difference. The bid of R.E. Harrington, like all bids, has MBE, WBE information in it. And what they did here was they committed to do the absolute bare minimum to the penny. They calculated, based on what they thought was their bid amount, to the penny what they were going to commit to do in the MBE, WBE situation. And because of these discrepancies, the rules say that you must adjust the bid, must increase it by $49,000. If you increase the bid by $49,000, the end result is that the bid no longer complies with the MBE WBE rules. It is under the goals because they are now below the threshold in both minority business and women's business.
How far under?
A percentage, but they're still under. They're under it's like being slightly pregnant. Either you are or you aren't. You ask for a waiver if you aren't. If you can't meet the goal, you ask for a waiver at the time of bidding. You know, the state and the city implemented a new process several years ago where you couldn't fix any problems with the papers after the bid opening. Everything has to be right at the time of the bid opening. You either comply with the MBE, WBE goals, or you ask for a waiver at the bid opening. We don't look at it again several months later and say, well, they almost made it, but they didn't. So if they didn't make it, this board has consistently said that that kind of a bid should be rejected. And we shouldn't make exceptions here because we start back down a slippery slope of the old days when contractors would decide if they were low and then go out and shop around with the minorities and get prices that were different than what they had at bid time. We have decided as a policy that's not a good thing to do. And so we look at it only when the bids are opened. If you do that here, if you follow your rules, which are very important to the process, particularly in the area of MBE, WBE participation, if you follow the rules, you have to conclude that they fail to meet the goals. It doesn't matter if it's $1 or $100,000, they don't meet the goals. It's just that simple. And so we would ask that that bid be rejected. Thank you.
Any questions? Inbo office want to say anything?
Mr. Council President, if it please you, I will discuss the whiteout first, and then Mr. Billups can talk about the EMBU issue if it, what the
That's good.
wish. In terms of the whiteout that was used here, the whiteout is on the scheduled prices only. That's a document that is signed only by the bidder. There's no subcontractor that signs off on that document. The alterations made by the whiteout are clear, and we can make out the numbers, we can do the math, we can figure out exactly what the correct bid amount is. We have done so. We have accepted these types of bids in the past. There is case law under the federal acquisition rules that allow the use of whiteout uninitialed on a bid when it's clear what was intended by the bidder in the use of the whiteout. So that's why we're urging and recommending that the bid be accepted. In terms of the duplicate bid, that's something that the Green Book provides we're not to consider at all in determining whether we're going to award a contract. We look at the original bid. The duplicate bid is not to be considered. So any mistakes in the duplicate bid, I can't explain them, but I don't see them. DPW doesn't see them. And it's not something that we present to the board for a resolution. So that's something that I think you should ignore in terms of the protest. And again, in terms of the protest, the allegation essentially is that the bid was altered, but there's been no factual presentation to say that these numbers were not put there by R.E. Harrington. And in fact, R.E. Harrington's numbers were read out at the public opening of the bid. Harrington has said nothing. R.E. Harrington has still to today not said anything about their bid being altered. So therefore, their bid is irrevocable. If this board awards the contract to R.E. Harrington is bound to comply with it, or we will go after their security. So that's what, if you have no questions, that's my presentation.
Courtney Billups, Chief of the Minority and Women's Business Opportunity Office. With respect to the issue of the adjusted bid amount, as stated earlier, the bid was increased by $49,000 due to the recalculation. That, in fact, I don't want to use the word diluted, but it reduced the MB percentage because the contract dollar amount increased to the MB goal of which is 12%. It reduced their MB percentage to 11.89%. So there was 1/1100th of a percent difference. With respect to the WB goal, which was 2%, it reduces to 1.98%, 2/100ths of a percent difference. My office made the determination that they did meet, in fact, they were in fact compliant, and that difference didn't warrant a finding of noncompliance.
Anything else?
I would just point out that the points that were made about whether or not the bidder has stated whether he's still intending to be bound by the bid that is in the bid amount that he has as his total bid is different than the bid that is before you today to be recommended. That amount is different, $49,000 different. the fact that he hasn't commented on that, I don't think we can draw any conclusions whether he intends to be committed. We're basically giving him a chance to take a second bite at the apple and to get $49,000 more, and on top of that, not comply with the MBE, WBE rules. These are all bad things, I think, and that this board should not participate in that kind of process.
Anybody else want to?
Mr. President, members of the board, my name is Robert DeShiel. I represent R.E. Harrington. I agree with the analysis and presentation made by the city representatives. Thank you.
If no further arguments, I would ask for a motion.
I move to deny the bid protest and the supplemental bid protest of Metra and approve the recommended award by DPW to R.E. Harrington.
Second.
All those in favor say aye.
Aye.
All opposed, nay. The motion carries. The final item on the non-routine agenda can be found on page 122 to 123. Baltimore Development Corporation, Harbor Point Development Agreement, and second supplement to the development agreement. Will the parties please come forward?
Want me to start?
Yeah, go ahead.
Okay.
Madam Controller.
Okay, I had some concerns, and I've had some discussions with the Department of Finance and with BDC. And my concerns as originally with this TIF is the 20% return on investment for profit sharing for the city. I think that it is highly unlikely and that it should have been renegotiated. Also, I have a concern about the cap rate that is being used. I think that the current cap rate should be used as opposed to the old cap rate. And while I am encouraged by the reports that I received from you regarding the employment and the number of jobs that have been generated, and especially for city residents, and I'm also, I'm glad that the MBE and the WBE participation has been favorable, and that the cost has been reduced because of better engineering calculations. But again, I am especially concerned about the favorable developers' return on investment. In my opinion, the hurdle rate is high, 20% before the city will start sharing any profit sharing. And also, given that MuniCap estimated that the market rate for the return on investment for the first building was 11%, I just feel that 20% is too high. Furthermore, my staff reviewed the but-for analysis by comparing the recent PricewaterhouseCoopers quarterly report to determine that the current cap rates for Phase 2 were properly applied, but we discovered that the rates utilized were higher than the average of PricewaterhouseCoopers, and we questioned the differences with MuniCap. And MuniCap advised us that the cap rates used for the but-for analysis were for 2014 and not 2016, and that the city staff and the developer decided that this rate would be used until the parcel is sold. But as an elected official and voting member of the Board of Finance, I was not made aware of the fact that the old cap rates would be used as opposed to the current cap rates. So critical information which affects the financial outcome of any city-related contract, in my opinion, should be communicated to voting members. Therefore, I am making a recommendation that all future issuance of TIF tranches, that we establish a policy and procedures that will require that the current cap rate would be used in the but-for analysis instead of the old cap rate, because we're issuing bonds under current conditions, and I believe that the current cap rate should be used for any additional issuance of bonds. Those are my comments.
Madam Controller, I'll address your last comment. The Finance Department will review that matter and prepare written policies based on the original cap rate versus current cap rate going forward.
Okay.
And we'll provide that to the Board of Finance.
Okay.
Madam Comptroller, Mr. Council President. Dan Taylor, Assistant Managing Director of Baltimore Development Corporation. As it relates to the profit-sharing agreement, the profit-sharing agreement was approved by this board in 2014, and as you mentioned, included a 20% IRR or return on the project that applied to all components of the project. That was consistent and remains consistent with the MuniCap analysis that was presented for market rate returns on the project, and that's why that hurdle rate was used.
Thank you. Mr. Raymond, make sure that that information is also shared with the BOE. Thank you. I'll entertain the motion.
I would move approval of the matters submitted to the board by the Baltimore Development Corporation on pages 122 and 123.
Second.
All those in favor say aye.
Aye.
All opposed, nay. The motion carries.
I vote no for the reasons stated above.
Please note the comptroller vote no. There have been no more business before the board. The meeting will recess until bid opening at 12 noon. Thank you.
The bid openings for Wednesday, July the 13th. The first item, the addenda for July 13th, 2016 is WC 1204 Druid Lake finished water tanks. Bid July the 20th, 2016. And the second is B 50004557. Provide a mass notification system due July 27th, 2016. Okay, hold on.
Excuse me. I'm sorry for the delay. Good afternoon. Stated the board is in session for the receiving and opening bids. I apologize for the delay. We have three addendum, rather two addendum. Thank you. The first is for I'm sorry, B50004557, and it's provide a mass notification system. Please change the bid due date from July 13 to July 27, 2016. Excuse me. The second addendum is for WC 1204. It's the Drew Lake finished water tanks. Please change the bid due date from July 13th to July 20th, 2016. Those are the addenda for today. Mr. Nelson, could you do
I'm sorry. Oh, so ordered. Addenda approved.
Thank you. B50004621. Tractors, various types. A bid bond is required if the bid is over $100,000, and that's a 5% bid bond. Finch Services, Inc., with a check, $308,191.84.
Refer to the Bureau of Purchases for processing. B50004643, and that is carpet, floor, drapery, and furniture cleaning services. And I'm thinking, and upholstery. But this I'm always accurate, so I try to read. This is how it was advertised. Okay. And for this particular item, a bid bond is not required. ACB Cleaning Services, $29,600. They just added the word there, but that's okay. Let's see if I can find it. Adonai 7 Services LLC, $24,750. Excuse me. Statewide Services, Inc., $15,190.
First one was ACB, right?
Okay, thank you. Thank you so much.
Right, right.
Yes, yes. Okay, thank you. Having error on my part. Okay. Thank you, Ms. Nielsen. ASB, 13,000. 25 revised, I'm sorry. It may not, yours may not have it, let's see. You know what? Here, check this one. They all say original, okay. It all says original, that's fine. This one here, though, okay. ASB, $13,700. That's how I was going to do this one. Okay. Okay. Boone Arang Consulting LLC.
I'm sorry, how much?
I'm reading it now. $26,850. That was a boomerang.
Refer all bids to the Bureau of Purchases for processing.
B50004645. Masonry and concrete repair services. A bid bond is not required. HEH Inc. $348,930. Tito Contractors Inc. $443,650. Colossal Contractors Inc. $186,930.
Refer all bids to the Bureau of Purchases for processing.
There being no further bids, we are adjourned. Thank you very much.